Please be seated. Morning, counsel. Court now calls case CV12-626, Smith versus Del Giorgio. This is the time set for oral argument. Counsel, these proceedings are audio and video recorded. I will note for you that there is a link to the court's website regarding this oral argument, and it will be up in a few days. I would ask that you identify yourself during the argument and your client as well. You both have 20 minutes. Appellant can reserve some time for rebuttal. If you wish to do so, just let us know when you come up to the podium. We've read the briefs, we've conferenced the case, and we're very familiar with the issues. So with that being said, there is a clock for you on the podium in front of you so you can keep track of your time. Counsel?
Thank you, Roger Foote and Brad Weech, for Martin Del Giorgio. Martin wanted to be here, but because of his elderly condition and medical condition, he couldn't be here. The first issue in this case, of course, this was a case that was tried to the court and Rule 52B language was inserted. So our review is going to be a little bit different than a normal trial. But the first issue was the doubling of damages on the Canadian property. And that was done pursuant to a statute, and the statute is ARS Section 14-3709. Now that specifically applies to property of the estate, and the statute itself talks about the right of the personal representative to the property. The Canadian property was not part of the estate, did not pass by will, and was in fact transferred prior to the death of Marie. And since it was prior to the death of Marie by a deed signed by both Marie and Martin, and the court upheld that deed, it could not have been property of the state. It was not property of the state, and any finding doubling the damages under ARS Section 14-3709 just is contrary to the clear direction of the statute.
What portion of Dr. Smith's estate was going to be transferred into the trust? Pretty much most of it, right?
I don't know. I wasn't at trial. I believe that most of it was to be transferred, with the exception of the real property, which is what we're talking about. So therefore, the real property is an easy issue. The statute doesn't apply on its face, and we can't extrapolate that it applies to something that it clearly does not. The second issue is with the $15,000 that was doubled. That was money that Martin possessed. He put it in an account. The description was that money was to go into an account, joint tenants with right of survivorship account. So that would have gone, had it been complied with, would have gone to Teresa Lewis, again, not to the estate. So under both of those issues, the statute doesn't apply, and the court could not double the damages. It just simply could not. The second issue that we have was the embezzlement. As to the embezzlement, there was no finding of fraud. You can't have embezzlement without fraud. It wasn't tried. So that needs to be stricken from the record and reversed.
Counsel, are you saying that the statute requires fraud? I mean, does the statute define embezzlement?
Embezzlement requires fraud.
Does the statute itself define embezzlement?
I don't know the exact answer to that question, I'll tell you that. But I know that the fraud statute, that in order to fight fraud, you have to have intent. And there was never a finding of intent or an intent to commit fraud or a fraudulent intent, which is a predicate to embezzlement under all the cases that I've seen.
I mean, did Martin deny that he didn't take the funds?
No, he didn't deny that he took the funds.
Or did he assert that he had authority to take the funds?
He thought he did. He had a lot of agreements, if you'll recall. He had a lot of agreements with Marie. They were also suing for all kinds of other monies, and there was offsets. And there were claims that this was the money that he was entitled to. So he had a belief that he was entitled to it. But it turned out that he was wrong.
But nonetheless, the court rejected that.
Right, but that goes to intent. If you had a belief that you were rightfully entitled to it, you can't have the intent to defraud, which is the predicate. And by the way,
where does the statute require an express finding on intent?
Fraud and fraudulent intent is part of embezzlement. I don't have the statute in front of me, so I can't.
I'm asking you, where does the statute require the judge to make an express finding on the intent?
Well, that's Rule 52A, Your Honor. 52A says you have to have all the predicate facts to find the conclusion. And if you don't have the predicate intent, you can't have the conclusion. I mean, that's why one of the reasons we asked for 52A.
And I'm assuming you objected to the Rule 50, the findings, asking the court to clarify.
Having this court ask the court?
No. I assume that in the trial court, when the findings came down, you objected and said you don't have sufficient findings. You need to clarify these.
Our objection was that it had not even been tried, so it had not been raised, and that there was no evidence of embezzlement. Embezzlement, when you make that, includes the intent.
That would be a motion for a new trial. But you didn't object to the findings of fact, saying they were insufficient?
I think if it's insufficient on appeal, that's why you're here. If the finding of facts are insufficient, you can see that, and therefore it can't be sustained unless they are sufficient.
In that, counsel, but in a lot of cases, and I appreciate you telling us what our job is, but in a lot of cases, we say, if you're going to object to the findings of fact, if you've requested findings of fact and and you think they're insufficient, you've got to object to them and give the court a chance to correct that. Did you do that?
On this particular issue, no. Our objection was that there was no evidence at all, not a specific finding of fact. On the Liz pendants, from the beginning of this case, there was no evidence, at least as to one parcel, and it's completely undisputed, as to parcel lot 243. It was never part of the estate, never any claim. It was bought by Martin bought by Martin as sole and separate property, titled in as sole and separate property, there was not even on the inventory and appraisement filed by Mr. Smith.
But counsel, wasn't it part of the overarching joint venture theory that was permeated throughout the case?
Just because I can claim it doesn't mean I have the law or the facts to go forward and to prove that. And that's what the statute requires. You have to have the law, under a good argument in the law, or the facts to do that. And there's no evidence in the record, none in the findings of facts, that particular lot was part of any of this.
How do we know that? We don't have all the transcripts.
Well, what you do have is you have the findings of fact. And the findings of fact said it was his, he bought it, and it wasn't part. So,
yes, but that doesn't mean that he's saying that there was no evidence whatsoever supporting the Liz pendants. He's just saying, I disagree with that. One of the premises here is that as the appellant, you need to give us the entire record, entire trial record, so we know. If one of the arguments is that there's no evidence that the Liz pendants was erroneous, was bad, because there was no evidence to support it, the fact that the trial court says the Liz, this is his separate property, doesn't mean there's no evidence support that the Liz pendants was good. It just means the court reached a conclusion based on the preponderance of the evidence. We need those transcripts to really say
let me go at it a different direction then. In order for them to get to the Liz pendants, they have to have a viable legal way to get there.
Okay.
Their claim was it's part of the joint tenancy, right? That's what they claimed. In order to get there, you have to look at the intent of the parties to the contract. We have two contracts in this case. We have the deeds, and the deeds are clear that it all goes to Martin. And we have the property division agreement, which the court found prior to the property division agreement, the parties agreed that they were supposed to go to Martin on her death. And after the property division agreement, the parties agreed that's how they're going to wind up their joint venture, and the property is going to go according to that joint venture, or that property division agreement. Under either scenario, they had no right in those properties. The only way they get to those properties is to take the deeds and the contracts, rescind them both, which the court considered and found it wasn't the right thing to do, and then reform them. And you can't have rescission and then reform. You can't. There's no case law that allows you to do that. In fact, they cite to Jennings versus Lee, I think it was, that says that's what the case says, but it doesn't. It says you can rescind and there were damages,
we don't know,
which is what they did.
We don't know if they present any evidence that would give them a colorable claim on the Liz pendant for the Liz pendants, because we don't have the transcript.
Right. I agree you don't have a transcript, but we do have the findings of facts and conclusions of law that says up until point A, this was what they agreed to, and after point A, here's what they agreed to, and there's nothing in between, which is what they're trying to argue. Okay. So they can't get to the Liz pendants. It was invalid from the beginning because their legal theory doesn't work with the facts or the law. The court found the facts, and the law said you can't rescind and then reform. On the issue of prevailing party, the court had a mathematical calculation.
Counsel, before you get there, let me ask you something about the lis pendens and the supersedious bond.
Okay?
If I understand your argument is the court should not have let the lis pendens stay in place. It should have required the estate to post a supersedious bond if it was going to do that.
After judgment, yes.
Did you take a special action to this court asking us to grant relief on the supersedious bond?
We did.
And what happened to that?
Denied.
Did you, in this appeal, file an emergency motion to ask us to review?
Did not.
Thank you.
Okay, and on that issue, of course, I think if it doesn't get quashed on judgment, the supersedious in Rule 7 means nothing.
When you filed your special action, did the panel decline jurisdiction, or did it deny you relief?
It declined jurisdiction, as I recall. On the prevailing party, the court gave a good explanation of how it came to that final decision, and it went through the calculation based on 34101A1 on the offers prior to the judgment, and the court was just wrong. Its math is wrong. It's in the figures in the court gave, and in the record, it shows that he's wrong. Therefore, his
Counsel, there's two offers, right?
Sure.
An offer from Martin, an offer from Smith.
right.
How was the statute applied in that instance?
It applies differently on who you're analyzing. In this case,
We have two offers.
right. In this case, it says you look at the offer that was rejected to see if that person is a prevailing party. That's what the statute says.
Okay.
But
But let's assume you're correct. Assume you're correct that Smith was not the prevailing party under that calculation,
Right.
and nor was Martin.
that would be the
And the
fact.
second part of the statute says that it's still discretionary. Doesn't the court have the right to go on and say, well, neither party fits under the sort of, I'll call it the automatic calculation sentence? Then can't the court go on to the next sentence and say, under the Warner factors, I'm going to apply these 8 factors, whatever, and I find that party A, Smith party, is the successful party. Can't the court do that?
If that was what this record was, the answer is yes. But in this case, the record is not that. The record is he went through the analysis, found the successful party, and after he went through found the successful party, he went through the Warner analysis to figure out whether or not it was fair to award fees. But look at the opinion and look at the way it is constructed. It's clear that he looked at that statute, and that's
Okay.
what he relied on.
Okay, understood. But go back to explain why the Smith offer was not greater, or at least equal to or better than what they actually received.
Because part of that offer had the 12-acre parcel being transferred to Mr. Smith. The court ignored that value in his calculation. That's the big elephant in the room in this case, is that 12-acre parcel. The lowball figure that they used in the inventory and appraisement was $112,000. Now, if you take that $112,000 and put it into what the offer was versus what the judgment was, the offer is less than, or the judgment is less than what the offer was. That $112,000 is what swings the pendulum so that they're not the prevailing party under that particular analysis.
All right, counsel, the question I have for you, when we look at the court's order, this was the amended order filed April 3rd, 2012, on page 34, and it talks about attorney's fees. The court talks about the amount of judgments that were awarded, the real property that was awarded. Then it goes into discussing who prevailed on which counts. You know the section that I'm talking about?
I do?
And then the court goes on to state, to this extent, Mr. Del Giorgio could be said to prevail against the estate trust counts 2, 3, and 4. He did not prevail on counts 1 through 6. And it goes through a similar analysis of the counts that the estate and trust prevailed on. When a court makes an award of attorney's fees under the statute, it looks at the overall litigation to decide who a winner is. It seems to me it's more than just a calculation of how much money was in the counteroffer. It was an analysis of when that court looked at all the counts that were filed, it found that the petitioner won on more of its counts and its claims than your client did. Why is that not a proper grounds to to make them the prevailing party?
Because you need to read the order in which the logic is placed in the order. And the logic is, I looked at all these things, maybe it's Mr. Del Giorgio, maybe it's Smith. We will look at, the way it's constructed, we will look at the settlement offers. That's what he ended up relying on.
No.
And he was just wrong.
That's not correct. He goes through, look at page 34. The court goes through who won on which counts. And then it says, to this extent, the estate trust could be said to have prevailed against Mr. Del Giorgio's counts 1 through 6. And it makes its findings as much on that as any counteroffer.
Well, I read it differently. Even if you get past that problem, or I get past that problem, the problem is that the affidavit for fees also is improper in that it lumps all the fees together, doesn't apply to any particular count or any particular plaintiff or defendant and whether they prevailed on this or that. And the estate, Your Honors, did not prevail on anything. If you look in it, the only way they can claim some win is because it says estate trust, but that's the problem with the judge. He did not differentiate between the two, and I'd like to reserve some time if I could.
Okay, counsel, thank you. Counsel?
Morning, Your Honors. I'm Rick Morrow. I'm here with Carolyn Williams. We represent Ron Smith in his capacity as the personal representative of the estate of Marie Smith and also as the trustee of the Smith Family Trust. Your Honors, you've already kind of hit on some of the key points I wanted to make, that we're going to talk here a lot about issues related to the real property, but as the trial court noted, this case was really much more about the big overall claim that Mr. Del Giorgio was making with respect to what he thought was his share of this overall joint venture that he and Dr. Smith had over 20 years, and he valued that claim at something close to $1.4 million at one point. And the trial court also noted in its final ruling that the primary focus of the case was also on the issue of whether there was a property division agreement and whether that property division agreement had been breached. Mr. Del Giorgio consistently denied the existence of the property division agreement throughout the course of the litigation.
Let me back you up for a second.
Absolutely.
Talk about the pour-over agreement or provision in the will with respect to the trust. Because
Well,
there's a lot of argument about separating the estate from the trust as two separate entities.
I understand, Your Honor, and there's no case law directly on point in Arizona, but we did cite to case law from other jurisdictions that clearly reflects that when you have an estate that has a standard pour-over clause, which we had here, and no one disagrees with that, that the estate and trust really become one entity. They're treated as an entity in and of themselves because anything that goes in the estate that's not used to pay taxes or whatever simply goes into the trust. And so under Haffenreffer, I think is the case from Rhode Island, and also just sort of general black letter law that came out of maybe Amger second, the estate and trust are treated as one entity.
The Canadian property, that was part of the estate, but it was transferred to the trust? Have I got that right?
The Canadian property was titled in the names of Dr. Smith and Mr. Del Giorgio, and the plan had been, based on the testimony at trial, and as found by the trial court, that Dr. Smith was in the process of transferring to the Smith Family Trust her interests in these various joint venture properties, which the court found all of these were joint venture properties. The court did find that there was a joint venture with respect to the real estate. As part of the plan, the property division agreement called for the Canadian property be transferred to the trust for eventual distribution to Teresa Lewis, who's Ron's sister and the daughter of Dr. Smith.
I guess it's kind of a chicken and the egg question. If it's property that's part of the estate, but it's eventually going to be part of the trust, it's still originally all part of the estate, correct? It has
Correct,
to be
Your Honor.
administered and transferred to the trust.
Yes,
But
Your
before
Honor.
that happens, it's part of the estate.
I would agree with that totally. So it's simply a stepped process. I mean, obviously it could have been transferred to the estate to be poured over into the trust to eventually be transferred to Teresa Lewis, but there was no need to go through all those steps. It was clearly part of what the parties viewed as being part of the estate. Did that answer your question?
Yes.
Okay, thank you. Now, of course, the trial court ruled here that there was, in fact, a property division agreement, and that Mr. Del Giorgio breached that agreement. And the court also found that with respect to the $1.3 million claim, Mr. Del Giorgio did not prevail. However, despite these victories by the estate, what we're really here about today on appeal is the relief that the trial court granted in conjunction with what the court called Mr. Del Giorgio's blatant breach of the property division agreement.
So if I understand your argument is we should have had rescission and reformation, so the estate would have a half interest in all the properties instead of double damages on the Canadian properties.
Yes, Your Honor. Our argument is basically the trial court, and this kind of fits in with the lis pendens argument initially. Obviously, title is at issue here, and Mr. Del Giorgio's claim is the lis pendens was improper because there was so little basis for the claim that the estate had to the real estate. It should never have been allowed to record the lis pendens in the first place.
Yeah, without all the transcripts, I'm not sure we're going to
Okay.
do that.
But at the end of the day, the trial court actually in its first decision found that the estate was entitled to half this real estate. So it really can't be a frivolous claim if the court, after very lengthy and careful consideration, and our kudos to the trial court because he did a remarkable job of trying to sort through all these issues and was very patient with us, and we really appreciated the awesome task he did here. But the problem is, after he granted us this half interest in the real estate in his first decision, he made a mistake in his granting of the motion to amend the judgment because he came to the conclusion, erroneously, in our view, that he could not grant rescission, which in both decisions he found was an appropriate remedy. But if he granted rescission, he couldn't put the parties back in the status quo they were before Dr. Smith's death.
That's right. I mean, because Dr. Smith, there's no evidence that Dr. Smith intended that they were going to share all of the properties 50-50, is it?
The evidence was, and it was found by the trial court, that in the months leading up to Dr. Smith's death, she was in the process of having Ron, the personal representative, who's going to be the personal representative, start the process of transferring these interests in the joint venture properties to the trust. In fact, there were even discussions about with Mr. Del Giorgio and some of the family members about how they were going to jointly develop the Canadian property because they were now going to be joint owners of this property. And so everybody was moving on the grounds that this is how we're going to split things up. And then the property division agreement came about as a solution to whether they all wanted to be in business with each other.
Is there evidence that as they were coming up to the point of getting into the property distribution agreement, that she said, okay, we're all gonna have 50-50 interest in all the properties?
Was that ever the evidence? No, not in that express or explicit of terms.
So, but that would be the effect of rescission and reformation, wouldn't it?
Well, that would certainly get you there somewhat easier than where we find ourselves today. But the court didn't believe that it could go back and actually create an interest in the estate with respect to those pieces of property.
That's because it felt bound by the title, right?
He did, even though he also found in both the decisions that regardless of the title, these were joint venture properties between Dr. Smith and Mr. Del Giorgio. He never varied from that. It was his concern that once Dr. Smith died, he couldn't go back and let her transfer the property into the trust as her intent had been.
Right, but it could be, the two could be consistent. It could be a joint venture, and they could have set up the winding down by virtue of joint tenancy. In other words, when Dr. Smith passed away, right of survivorship, it goes to the appellant in this case.
Absolutely, they could have set it up that way, Your Honor. No doubt about it. But the court also found that they had never made a decision other than the property division agreement with respect to how that winding down was supposed to take place. That the property division agreement took over and became that agreement.
I understand that, but before that, the only express intent that they ever had was how they titled that property. And the fact that it was a joint venture really, in some ways, is beside the point, because joint venture or not, the way they titled that property, it set up the right of survivorship. They had a means to wind down their joint venture by virtue of the title. And I think the court had trouble walking away or departing from that clear express title that was on these properties to start getting into some other evidence that way, and that's why I don't felt it could reform the documents. I mean, isn't that what happened?
I think that was where the court came down, yes, Your Honor. But I don't think he had to come down that way. That's why we think his first decision was the correct one. Because under cases like Jennings versus Lee and the Lonergan decision here in the state of Arizona, the court is not strictly bound by the concept of having to find a status quo that they can put the parties back into, because sometimes that status quo simply doesn't exist anymore.
Counsel, maybe the court didn't have to come down that way, but I guess the question before us is, could the court come down that way? Could the court act within its discretion in fashioning a remedy here and not have that be a reversible error? That's the question before us.
Well, we certainly believe that it was reversible error. He was right the first time.
And how is the argument on reformation, how is that consistent with sort of benefit of the bargain damages here? Benefit of the bargain. I mean, in essence, you said there was a breach. The court found that there was that Martin breached the contract, no doubt, right? He breached the property division agreement.
Right.
How does reformation and how does it resolve and give your clients the benefit of their bargain under the property division agreement?
Well, because, Your Honor, you have to look at the sequence of events. The first sequence of events is Dr. Smith was in the process of transferring the properties to her trust, to her family trust. And that process stopped because of the property division agreement. That property division agreement was inconsistent with everybody having a half interest in all the real estate. And so at that point, the process stopped. But because of the breach by Mr. Del Giorgio, which allowed rescission, to put the parties back in the status quo as to where they would have been without the property division agreement, would require you to have Mr. Del Giorgio transfer a half interest in the real estate to the trust, because that's where they were headed.
Okay.
It was only the property division agreement that caused the detour.
All right, which of course, going pre-property division agreement causes you to go back right to where the deeds, and you have the problem, if you will, of the intent manifested through execution of all these deeds that said, we're going to deal with this in this manner.
I understand, but the intent also, as found by the trial court, was that was not, the deeds were not the final outcome. The deeds were not the final decision with respect to how to divide up the joint venture. And then instead of Dr. Smith transferring a half interest to her trust, they did the property division agreement instead. And that's where our case focuses.
So you're saying, and I may have misunderstood earlier, you're saying there is evidence that Dr. Smith, prior to entering into the property distribution agreement, wanted a 50, the intent was, it was heading in the direction of a 50-50, everyone would, Mr. Del Giorgio and her estate / trust would each have a 50% interest in all the properties?
Yes, Your Honor.
And do you have transcripts that support that?
No, but the findings of the trial court support that. The judge himself, in his findings, finds those things. Let me briefly discuss the attorney's fees issue, Your Honor. I'm glad to talk about this more. I'm not trying to shut you off, but
let me before you change
absolutely.
Gears. There was a special action on the supersedious bond issue?
On the remove of list pendants, yes, Your Honor.
Okay, and what happened to that?
The court declined jurisdiction.
Do you have a case number on that?
I have it's in here. Hang on. I do have that. It was 1 CASA 13-0030.
Okay, thank you.
I just want to briefly talk about the attorney's fees claim. You've already picked up on the points I was going to make. The trial court did not just look at the settlement offer made by the estate and compare it to the final outcome. He clearly went through very carefully who prevailed on what claims were the primary claims. There's a very good quote from him right out of his attorney's fees decision where he talks about the fact that the primary focus here was on both the claim of the overall partnership and the claim with respect to the property division agreement and Mr. Del Giorgio's breach of that. The trial court also expressly granted the attorney's fees under ARS Section 143709D as well as the contract statute.
So does that make all the discussion about 1234101 moot?
No, Your Honor, I don't think so. But I think it simply supports the fact that he
I mean,
looked
if you've
at
got two
several.
statutes that support a fees, why do we need to turn to 1234101?
You might not need to. But in determining whether to award fees and the amount of the fees, the court did go through the associated indemnity Warner factors and carefully looked at each of those factors.
And that would apply to either one.
I would think so, Your Honor, because
To
you'd
either
have
statutory basis.
you'd have to look at how to go about doing it.
Right. And you're asking for fees on appeal
Yes,
under
Your Honor.
both 34101A and the other statute?
Yes, Your Honor, we are. Now, on my cross appeal, am I allowed to reserve a few minutes for rebuttal? And if so, I would like to end at
That's
this
fine.
point.
Yes.
Unless you have other questions about other issues. You know, because of the limited time here, we're relying on our briefs with respect to the other issues. We're certainly not intending to waive anything, but we think it's clearly briefed.
Just one administrative question. How much in amount, I know the court awarded $300,000 in fees, but how much was requested? Was that the full amount requested?
Oh, no, it was quite a bit more was requested, but we also deleted from our request quite a few items on issues that were never tried and went through and segregated out, you know, and reduced our fee request just as you're required to do under China doll.
All right.
So it wasn't just,
Okay.
here's all the fees, Judge, give us all of it. No, we used discretion to cut that back, but it wasn't all the fees we requested.
Apologize that I didn't have time to cover every portion of the record.
I
Little
can't
hefty.
understand why not. Your Honor. Thank you.
All right, thank you, counsel.
Let me first address a factual issue that I think is important. The Canadian property was transferred to the trust prior to the death of Marie, uncontested. It could not become part of the estate if it was transferred prior to her death, and since it could not become part of the estate, the statute could not apply. That's that simple. Getting back to the attorney's fees issue, and you talked about the amount, and what we have to remember that as under the case law, it is their burden to give the court sufficient information so that the court can determine the successfulness of each party in regard to the various claims, and where claims are litigated separately, the court must look at those separate claims. Court could not do that because their application did not segregate what was for who, what was for what claim, and it was just an amalgam. In other words, dumping it on the court and say, this is what we're entitled to, and the court cuts part of it off. That's not the analysis required by the statute. That's not the analysis required by the case law. So simply putting it on there and the fact that the judge finds an amount does not comply with the law that they have the burden, first and foremost, to put it down and put it down correctly and properly and break it out. Secondly, on their claim with respect to the reversing of the courts because the court didn't believe it could convey the property or couldn't rescind and reform as they wanted it. The court focused on the intent of the parties, not what Mr. Smith wanted to accomplish. The court said before this agreement, that's what it was. After the agreement, that's what it was. The fact that there may have been discussions of something different does not mean that that's where they were going to end up. And if you'll check the record, there's nothing about 50-50 split. And if they were to get to that point, the court would first have to do an analysis of the accounting between the two and adjust the accounting based on the work and the amount of money put in. That was not even the evidence. They could never get there from the beginning, and there was no evidence to get them to that point. And I think the court properly focused on Was there an abuse of discretion when the court found that rescission was not equitable and specific enforcement was what was going to happen? They asked for specific performance. They got specific performance. You can't say it's an abuse of discretion if your whole case was based on here's what we want and we got it. That's judicial estoppel, Your Honor. That is judicial estoppel. They didn't mention, but on the dead man statute, I think that's a red herring. The court said it didn't listen to that evidence, but the footnote shows that there was conflicting evidence on an issue of the A-frame. That only comes if that evidence is let in. There's nothing to that particular claim. But in final, Your Honor, the issues of the double damages on the Canadian property just are wrong. That was one of the main bases for the court awarding fees and finding the successful party. And the fees awarded were improper because the application did not conform to what the law requires. We requested the court would reverse the double damaging of the Canadian property and the $15,000 that went to Teresa Lewis, find that there was no embezzlement, there's no facts, no findings of fact, which are a predicate to finding that, was not tried, find that the Liz pendants were in fact baseless because as a matter of law, you can't rescind, reform, and then reform it to something that no one ever talked about or no one ever even thought about. And find that neither party or the prevailing party below or possibly send it back for remand after this court's hearing. Thank you, Your Honor.
Thank you, counsel.
Thank you. My incredibly competent associate did point out to me that in connection with the cross appeal, we did provide certain portions of the transcript that do discuss Dr. Smith's plan with respect to transferring her half interest in the property. So there are some references to the transcript in the appellate record.
Is that primarily as to the A-frame house, though?
Much of the focus there is on the A-frame house, but it certainly fits in with this entire concept of what the parties were going through with respect to how to divide up the real estate. And I want to just point out one particular part of the court's April 3 ruling. It's page 25, paragraph 20. And it expressly says, because the remedy of reformation is not available, the remedy of rescission of the property division agreement would not restore the estate trust to a position substantially equivalent to that which it occupied before Mr. Del Giorgio's breach of contract. It's that first clause that's the trial court's error. He did have that authority. He exercised that authority properly in the February 3 decision, and the February 3 decision should be the one that stands. Any further questions?
Question. I guess ultimately what the trial court was trying to do was make the estate whole. That's
Yes,
a
Your
fair
Honor.
statement.
I think he was.
Why don't the double damages do that?
It depends on whether you're going to uphold the double damages, I suppose.
Assuming we affirm the double damages, why wouldn't that make the estate whole?
It probably gets the estate back to about an equivalent position, particularly with the award of attorney's fees as well.
Okay, so if we affirmed on the double damages, your rescission reformation really isn't, we don't really have to be concerned about, and of the attorney's fees. We wouldn't have to worry about the rescission reformation?
Well, one assumes collectability and a lot of other issues in that question that's not in your record before you, but certainly having a half interest in the real estate would be a more secure position for the estate as opposed to just a claim for money damages that may or may not ever be collectible.
Okay.
Thank you.
Any other questions? No. All right, thank you, counsel. We'll take this matter under advisement. We'll issue a written decision in due course. Court's in recess.
seeing each other again.
I don't know, maybe there are a couple of lawsuits against each other.
Well, we may or may not be seeing each other on this case.
Well, I kind of hope not.